All right, so welcome to part 6 of residential purchase agreement. And this will be the old version. This was the RPA, or the purchase agreement, that was revised in December of 2018. And we're going to see a new revision in December of 2021. And I was able to send that out, and that was compliments of Larry Christian, who's on with us today. So I shared that with you guys in last week's email. So if you weren't paying attention, you got a copy of it. And it is a sample, so there may be some changes. My name is Alex. Today is November 3rd of 2021. And this is part 6 of the 6-part presentation that I put together with my opinions and slides that I put together here about the purchase agreement and how we should interpret it. I'm not an attorney or an accountant, so please take what I say with a grain of salt, but I do like to share. So as you guys know, this is the reason why I put this stuff together. I have sent out the channel link to a few folks already, and just kind of giving it a test on how it's working. So here in the next couple weeks, if you are receiving my emails, the link will be there, and it'll be the same link. And what it does is it gives you access pretty much to all of the recorded meetings. And right now, I think there's 19 that are up. After today, there'll be 20, because this will be the 20th one. And I'll be doing some new ones, some revisions coming up in November. We are going to take a break because of Thanksgiving week, and possibly the week after. And then maybe we'll do a couple of presentations in December, and then probably take a couple weeks off there as well at the end of the year. Okay, so just so you know how the upcoming schedule is. But come up January, we'll hit the ground running again, finish off with all the rest of the ones that haven't been recorded. And then there's some new ones that I'm putting together. One of them is FERPTA or the seller's affidavit and those responsibilities. And then also I'm putting one together for the AVID, for the agent visual inspection. So look out for those, okay, guys? Thank you guys for logging in early. So we can get started here. Excuse me, I had to clear my throat there for a second. I do a lot of talking, so especially coming into the presentation, never a good thing to have a frog in your throat, right? So anyway, that said, there's my information. You guys are welcome to call me, email me, or check out my website. The website's down at the moment, says Wix. And so there's some revisions that I'm doing to it, what have you. And but again, feel free to call me anytime, okay? I mute you on my side, okay? So all of you guys are muted at the moment. I'm assuming you guys can hear me okay. I see my microphone jumping up and down. But I do like a dialogue versus a monologue, meaning that I want to talk to you guys, okay? So feel free to chime in anytime, okay, if you have a question or comment. But you can also put your question up on the chat, and I'll try to get to your question after each slide, okay? And that I just said. So thank you guys for logging in early so we can get a good start on this. I'm hoping that this particular presentation doesn't go the full hour and a half, although it might, just depending on questions and comments. The last 2 pages of the RPA are primarily definitions and descriptions of things, but there is some things there that we should all know and we should be familiar with, right, when we're using the RPA and or we're dealing with clients and have to deal with the other side. A lot of times it's the listing agent or even the selling agent that needs to know these things. So that said, anybody's invited, licensed or not, any age, doesn't matter. Anybody's interested in the real estate field, they're welcome to log on and join us. And then obviously when you get the link for the recorded versions, they're welcome to watch those too. Okay, so excuse me. That said, any questions or comments before we get started? All righty, so let's do a little overview. Okay, so in part 1, we went over what we must first understand, what it is that a licensed agent does, right? This presentation has been separated into 6 parts designated for separated day training. Oh, wow, look at that. I have a typo. This is part 6 of 6. not part 4 of 6 as the slide says, okay, but this is what we covered actually in the first presentation that we did, was actually more of some of the addenda that's attached to the purchase agreement, which is all of these forms here. And then obviously there's a new one that wasn't added here, which is the FHDA, which is fair housing disclosure, 2-page disclosure. I encourage all of you to read that. It does apply to what we do in terms of people's behavior. So, we have to be clear. Remember, it's not what you know, it's what you can prove, okay? So that was part 1 presentation. Right, part 2, we covered what an offer is and the tools we use to give your client proper representation. We started with sections 1 through 7 on that particular day, right? We covered the many different types of purchase agreements. We'll focus on the one that we mainly use as agents, which is the RPA, the residential purchase agreement, that 10-page monster that we deal with every day. But purchase agreements can be more specific. It's important to know that they at least exist. And I actually got one today. I got a PPA today, which is a probate transaction. A little surprised because the agent that I'm working with is a little green. So I was a little surprised about that, to even see that, because I've had seasoned agents not even use that form. Can you still use the RPA? Yeah, you still can use it, but then you have to incorporate addenda to cover some of the things that maybe aren't talked about in the RPA, right? So these are some of those on the second presentation that we did, talked about those different kinds of purchase agreements that are available. And then obviously the last one, the one that we use the most, the RPA, but there's the income, the probate, notice of default, new construction, condominium conversion. Those are the ones we covered in part 2, right? Any questions or comments so far? All righty, and then in part 3, we went over section 8, 9, and 10, which starts on page 3. These sections discuss what is being proposed specifically, but what happens at closing, whom is to retrieve possession, the process of disclosure, and the buyer and seller's ability to cancel, right? Those sections included lease and lien items, right? Solar panels, water softeners, security systems, that kind of thing, right? Closing in possession, sometimes the seller is to remain in possession by request, and then also the tenant. These are terms and conditions that one has to agree to when making an offer, right? You don't bring up this surprise later on, and then a buyer would have the ability, if that happens, would have the ability to cancel if they don't like that idea, right? So those sections, section 9 would cover that section, and then statutory disclosures and cancellation rates. And then there it talks about what is required or statutory by the state, which is natural and environmental hazards, FERPTA, which is possible non-resident alien ownership of a property, Megan's Law, which I think you're all familiar with, notice regarding pipelines, liquid pipelines, and then condominium and plan unit development disclosures, okay? And that's typically HOA disclosures that are included in those transactions that actually become a contingency to the transaction. So understand that normally we look at the 3 primary disclosures, which are, contingencies, primary contingencies, which are investigation, appraisal, and loan. But now HOA docs becomes a contingency to the transaction, because if you don't get them, you still have an open contingency, right? And that's in section 10 of the RPA at current, and that's probably going to change. So we have to familiarize ourselves with the new sections coming up here in December. And I believe I saw the date, I think it was December 21st, that new RPA will be coming out and probably hitting zip forms for us to look at it and then start using it, okay? Any questions or comments on that slide? Okay, and just as a quick overview, real quick, there is 21 slides today. We're already on slide number 6. So moving pretty quickly here. In part 4, we will begin at the top of page 5 of the RPA section 11 and continue sections 12, 13, and 14 from page 6. Okay, these sections talked about the condition of the property, the as-is clause, which we kind of got into pretty heavily. the buyer's investigation rights, title investing, contingency periods, and buyers and sellers' rights to cancel. Now, the seller's right to cancel really is just primarily one thing, and that's only if the buyer doesn't perform. Other than that, the seller really doesn't have a right to cancel the transaction because they're now under contract. Okay, so Larry has a question or comment. And PPA, if agent doesn't know they need to use it, sometimes can be a rejection of offer just because attorney or paralegal thinks you don't know what you're doing, and they will move on to other offers on the appropriate forms. Larry, what's an NPPA? I'm assuming.
Maybe it's the PPA that you talked about, the probate.
The probate purchase agreement.
Yeah. So at that point, I've heard that comment from a number of attorneys that if that comes in that way, you don't know what you're doing.
If it comes in other words, is the RPA.
Right. Correct.
Yeah. So yeah. Now normally there is an attorney involved in probate purchase agreement or probate purchases typically, and it's mainly because they're usually need some kind of court confirmation. Can a petitioner petition the court themselves? Yeah, they could. I wouldn't recommend it, but yeah, you would be dealing with an attorney the majority of the time. And the reason I say that is because I did deal with a probate one time that didn't have an attorney. We got it closed. I mean, it was a little more difficult. There was some additional brothers and sisters involved, but at the end of the day, I would concur with what Larry's saying, and that if you are dealing with a probate transaction, you should use the PPA form. Okay, so that said, thank you, Larry, for that. So we were talking about page 5 and 6, sections 12, 13, and 14, and those sections include the condition of the property, the buyer's investigation of the property matters affecting it, buyer to indemnify the seller, right? Remember we talked about how you can't bring an inspector in, and the inspector can't start ruining the property to try and get information, right? The inspections that are supposed to be done on a property are pretty much just visual, very little touching, right? And if there is any touching, no damage. And so the buyer is to indemnify the seller of that, right? Title investing, time periods, removal of contingencies, and cancellation rights. Again, seller's right to cancel, which again, it goes in detail as to, you know, pretty much if the buyer doesn't perform. Notice of buyer seller to perform, meaning that, hey, if you're going to give the other side a notice, or you plan on trying to cancel the transaction because of non-performance, you have to give a notice first. You have to give a warning, and usually it's to the tune of 48 hours as well, right? Not all the time, but most of the time, 48 hours is built into the contract, and that can be changed, right? Effects of buyer's removal of the contingencies. So once they remove contingencies, pretty much what it's saying is the effect is now your deposit is exposed, and you are kind of forced to close this transaction, right? Close of escrow, and talks about that in, I believe, in section 14 as well, and effective cancellation on deposits. So it actually talks about what could happen if you remove contingencies and those effects that could happen once your deposit is exposed. You know, most buyers ask this question, hey, does that mean I lose my deposit? Yes, if that is what happens. Normally, you've pretty much done everything you possibly can to make sure that you're going to close the transaction before you remove those contingencies. So that doesn't usually happen. So I would say in my 32 years of real estate, I've only seen it happen once. And, you know, it was the fault of the buyer. The buyer just kind of assumed that, you know, everybody's just going to play nice, and that didn't happen. So most of the time, I mean, you guys might have stories of that happening, but I've only seen it once. The majority of the time, anytime there's been a cancellation, I've seen the buyer get their money back. And the other part of that is escrow also charges a cancellation fee, right? And I've even seen escrow companies don't even charge that. They give it back to them. So, you know, talk about playing nice. Usually the escrow companies do play nice. Do they always? I would say no. You know, I can't guarantee that every escrow is going to act nicely, but the majority of them do. You know, they want your business and they don't want to, you know, stir the pot, so to speak. So any questions or comments on that slide? Excuse me, on overview, right? So let's move on to part 5, which was last week. We covered pages 7 and 8 of the RPA. It includes section 15 through 22. These sections cover the final walkthrough, repairs, taxes, broker's compensation, escrow holder, liquidated damages, mediation, and arbitration. And that was a mouthful, but for the most part, we didn't get too heavily into that last week, mainly because the majority of what it talks about there is very legal, right? And the majority of us have no intention on going down this road. So pages 7 and 8 are usually collecting dust, right? But for the most part, it is something that is required on a contract, mainly because disputes sometimes come up, and you know, there are things that sometimes cannot be avoided. And so this is a step back position from just going on a full-blown lawsuit over something that is kind of the brainchild of the National Association of Realtors and the California Association of Realtors. They say, okay, well, instead of going a full-blown lawsuit, why don't we just take a step back and maybe we'll have a retired judge sit in and listen to your guys's sides, right? And then they'll give a recommendation as to, you know, what could be done or who's right or who's wrong in his opinion, right? That's called mediation, and it's non-binding, okay? But let's say that the parties still don't agree even after that happens, after mediation. Well, then you agree to go to arbitration, which is binding, okay? And a lot of times now it's 2 or 3 individuals that are judging your case, kind of in the same setting. It's kind of like an office setting, okay? Now that decision is binding, meaning that now you have like you won the lawsuit, so guess what? Pay up, right? That's how that goes. And then does that mean at that point, if the parties don't agree to arbitrate, that you can sue? Yeah, you can. There is no limitation to lawsuits, but there are exemptions, like small claims. In other words, you can go to small claims court, and that's an exemption to mediation and arbitration. So just know that those things exist. And like I said, usually those pages collect dust for most of us, but for the most part, you should know what your rights are. And it talks about that on those 2 pages. So take the time to, you know, do yourself a favor, take the time to read those 2 pages. It is a bit wordy, and it will allow you to research some things, okay? But those sections included the final verification of condition, repairs, proration of property taxes and other items, broker's compensation, representative capacity, joint escrow instructions to escrow holder, remedies of buyer's breach of contract, liquidated damages, dispute resolution, and that's what we just talked about, mediation and arbitration, right? So those pages talk about these things, which again are necessary in a contract, or necessary to be talked about, because people, and you know, God bless them, people will always challenge what it is that you're supposed to do. So if it's in writing, guess what? You can prove what you're supposed to do or what's supposed to happen. And that's because it's in writing. And I would venture to say that that's the reason why the new RPA coming in is 16 pages, because they're adding more stuff that we can prove, because there's probably some lawsuits that came around, or there's probably some complaints that came in. And I can already tell you one of them that came up, and that has to do with the appraisal. And I don't like it, but it's there. I read it. So this is the reason why all of this is there. I mean, why do we need to talk about the broker's compensation? You know, hey, we're all kind of on the same page. Why do we need to talk about, you know, the escrow instructions and liquidated damages and representative capacity? You know, oh yeah, it's in a trust. You know, we trust those people that they're signing and they have the ability to do it. Yeah, because title is going to insure the deed, right? That's because you're going to get some people that start to play games. You're going to get some people that are misinterpreting what they think is supposed to happen. So it's better to have it on the contract. So that's why it's there. And so us, because we chose to be real estate agents, we should know this stuff. So do yourself the favor, pick up the entire RPA, the new one, and read it, right? I don't suggest reading it in one shot, 1 or 2 pages, maybe every other day, or 1 or 2 pages, you read them every other day, the same pages for a week, and then move on to page 3 and 4 the following week, right? You'll absorb more that way. So anyway, questions or comments on part 5 from last week? All right, so let's move into today, which is part 6. We'll cover pages 9 and 10, which is the end of the RPA, and include sections 22C, 2 and 3 from last week, and continue through sections 32, which is the last section of the RPA. These sections cover service providers, MLS, attorney's fees, assignment, equal housing, time of the essence, and definitions. Okay, so these are the things that we'll be going over today, and primarily because they're on pages 9 and 10. But as you can see, the RPA covers a lot of stuff, right? To the tune of 32 sections. That's a lot of stuff, okay? And how sad that we cannot be cordial with each other enough that we have to continue adding more stuff. Because I didn't look at how many sections the new RPA has, but this old one has 32 sections. I can imagine on 16 pages, there's probably going to be more, okay? So these sections include selection of service providers, right? The MLS, attorney's fees, assignment, equal housing opportunity, time of the essence, entire contract changes, right? Definitions, which is almost a whole page just on its own. Expiration of the offer, acceptance of the offer, the real estate brokers, and oddly enough, there's just one line that the real estate brokers are not parties to this transaction, or I'm sorry, are not parties to the agreement between buyer and seller. Escrow holder acknowledgement, right? And then rejection and or presentation of the offer. So that's actually something that we have to deal with. Obviously, if there's 32 sections that need to be read and understood on an offer, it should be properly rejected if it's not being accepted, right? And then also properly presented as well. Okay, so we're going to jump in here on slide 8. We're at 624, so we're moving along pretty good. So any questions or comments thus far? All right, so let's jump right in, guys. Okay, so selection of service providers. Okay, brokers do not guarantee the performance of any vendors, service, or product providers, whether referred by the broker or selected by buyer, seller, or other persons. Buyer and seller may select any providers of their own choosing, right? So, we've talked about steering before, right? Whereas, especially if you're doing the loan, right? There are other documents that buyer and seller need to be properly disclosed, right? But in terms of service providers, what the attorneys at CAR have done is they have added this in here, pretty much telling the buyer and seller as they should read and understand this contract and or purchase agreement, that they have the ability to hire whoever they want. Now, does it mean that the broker can't suggest somebody? No, they can. We just, as brokers, try to avoid steering. We do not want to be accused of being in cahoots with a service provider or getting any kind of compensation from anybody that we refer, right? We don't want to be accused of that. So this is the reason why this is here, right? It gives them that disclosure, if you will, right? Or advisory. What is it called if broker or agent insists on a service? And I just used that word. I hope you guys all remember what I said. But it's steering, just so you guys know. I don't want to tie you guys up with questions today. Does the buyer have the right to choose their own title and escrow service? And so these are called settlement services. Settlement services, and actually, the answer is been highlighted above, right? The buyer and seller may select the providers of their own choosing. Well, that's the question, okay? But RESPA 9, right, actually says that the buyer has the right to choose their own settlement services, right? And that's, I believe, in a federally related mortgage loan is involved with that, okay? So can a seller insist on an escrow company if that's the situation? Under RESPA 9, if the buyer doesn't agree, the buyer actually has precedence now in terms of being able to choose their own escrow company, right? And then also title company. So that title insurance cover the property by purchased by the buyer from any particular title company. So if under RESPA 9, if federally related mortgage loan is involved, RESPA 9 under California Assembly Bill 957, right? And I won't go into the chapter. Allows the buyer to choose their own escrow company under those conditions. So it's not a blanket statement. Okay, understand that loan has to be federally related, right, in order for this to apply. Okay, no seller of property will be purchased with the assistance of federally related mortgage loan shall violate Section 9. Defined required use of a provider of a settlement service, right? So it just goes on into 12 CFR, right, which is the government code. Required use means a situation in which a person must use a particular provider of a settlement service in order to have access to some distinct service or property, and the person will pay for the settlement service of the particular provider or will pay a charge attributable to or part of. So that's kind of like a fine, right? So if they're saying that they're required to use that service, right, the opposite party will pay that service. So understand that if a buyer goes in and says, okay, I want to use XYZ escrow, and the seller says, oh, no, I'm requiring you to use this other escrow, right? And it happens to fall under the provisions of RESPA 9, the seller has to pay for that service. So there's a fallback position there, because think about it. If this is being violated for whatever reason, that's the consequence, right? Yeah, because if you think about it, well, what's the consequence? If they end up using another escrow company, what's the consequence? Well, there isn't one really, but what the lawmakers have said is the consequence is that they will have to pay for the service, right? So I thought this was kind of interesting, even though it's just a literally a 3-line paragraph. It kind of, this brings up arguments and conversations and discussions about this particular matter, right? Who is supposed to be the escrow entitled? Normally listing agents will say, oh yeah, well, the seller's to choose the title and escrow, right? Well, as you can see here, that's not always the case, right? So this is, you guys now know what it is, RESPA 9. You're welcome to look it up and research it. It is interesting reading. Okay, so Section 24, the multiple listing service brokers are authorized to report to the MLS a pending and/or close of escrow. The sale price of other terms of the transaction shall be provided to the MLS to publish and disseminate to persons and entities authorized to use the information on terms approved by the MLS. Okay, so now we're kind of going back to us actually signing up for a multiple listing service and or the board that we belong to, right? And so this is pretty much telling these individuals, buyer and seller, right? And it could be multiple parties, pretty much telling them that we've signed up for this and we're required to do these things. These are MLS rules. So now we're telling our clients exactly what it is that we're supposed to be doing under those rules, right? Why is this here? Well, that's primarily the reason, right? This is more of an advisory to the signatory that the broker will be posting the information of price and other terms publicly, right? And why is that important? Anybody? Why is it important that we advertise this publicly? Anybody have any idea why we publicly publish prices and sale dates? I'll answer it real quick. It really has to do with transparency, right? Because real estate and housing is probably one of the most important commodities that we have as human beings, right? If you were to hide that information, it would make it that much more difficult for anybody to be able to finance anything, because it would make the lending institutions, it would increase their risk factor. So in order to decrease their risk factor, they make that information public. So that just becomes more of a rule. That kind of goes along with some of the things that we talked about when it came to the title and ownership sections, that we do other things that are public, like size, age, right? And then obviously you have social media that kind of makes things public in terms of condition. You know, sometimes you can see the condition of some people's homes, right? So we make these things public and transparent to make it easier to attain. That's the purpose of what we call public records. You could pull public records pretty much on any home, and we all have access to it as realtors, right? And that's the reason for it, just so you guys know. So moving on to sections 25, 26, 27, and 28. So 25 is attorney's fees and any action, proceeding, or arbitration between buyer and seller arising out of the agreement. The prevailing buyer or seller shall be entitled to the reasonable attorney's fees and costs from the non-prevailing buyer and seller, except as provided in paragraph 22A, which I don't remember what 22A was, but it was except mediation. Okay, so you know, most of us kind of think, well, you know what, if we sue somebody and it gets to that point, who pays the attorney's fees? Well, this is where it talks about that, right? It talks about that the prevailing party, right, is the one that actually will realize the other side paying their attorney's fees. So if you're going to sue somebody, make sure you're going to win, right? So now section 26, assignment, and this is always very interesting. Buyer shall not assign all or any part of buyer's interest in this agreement without first having obtained the separate written consent of the seller and specified assigning. Such consent shall not be unreasonably withheld. Okay, so some of you may not be familiar with this word, okay, but assignment simply means, so in terms of putting it in terms of an example, okay, let's say that I am purchasing a property, and I give an offer to a seller, and they accept my offer, okay? But at some point, let's say that I say, you know what, I want, because I'm the buyer, I want this other person or entity, let's just say it's a company, okay, to now purchase this property, and some people actually charge a fee for that, okay? So let's say that in order for me, for this new guy that's coming in that wants to purchase this property, let's say I'm going to charge him 10 grand. I said, hey, Mr. Buyer, I'm going to charge you $10,000 and I'll assign this contract to you, okay? The only thing though is I need the seller's consent, because the seller could say no. The seller could say, oh no, you don't have the right to assign this property to anyone else, or I'm sorry, to assign the contract to anyone else, because it's the rights to the contract, not to the property, okay? The seller could say no. Now, can you write a provision in the original contract saying that you want equitable assignment rights in order to do that? Yeah, the seller a lot of times doesn't even see that you put that in there, okay? So it's kind of a tricky thing. But this is where now the last sentence that I highlighted says such consent shall not be unreasonably withheld, meaning that it should be open knowledge that if you plan on assigning your contract to someone else, the seller should know about it freely, okay? Now, if you're going to assign the contract to someone else, and those of you who don't, I mean, those of you whom are familiar with what I'm talking about, the other word for it is wholesaling. So I own a contract. I'm going to sell it to buyer number 2 with the seller's consent. And I'm going to do it with the form AOAA, which is at the end of the sentence here, or I'm sorry, the end of the paragraph, right? That's the form that you would use in order to add somebody to a contract, which sometimes happens in like marriage situations or qualification situations, right? So you're assigning partial interest of your purchase contract and you're adding somebody. So you would use the AOAA, okay? But let's say that you're coming off completely and you're adding somebody on completely, you would use that same form. It has both of those options. But assignment, right, could be also used in other words, or a synonym would be wholesaling, okay? Because this is how you would wholesale a property. Now, there are individuals that try to wholesale a property without having it under contract. That is highly illegal. That is actually a federal crime. If you pass a phone number and collect a fee, right, that is a federal crime. You have to have it under contract. It has to be in your name. Okay. So I'm not an attorney, but I just happen to know that. Okay. So that's section 26. And there's that famous form AOAA. If you're going to add somebody to the contract, or if you're going to take yourself off, or a buyer taken off and then add somebody else on, that's the form that you would use. Now, it's also given the assignment provisions here is that the seller needs to know what's happening and you have to have their approval. Any questions or comments on that? And I already answered this question. Can assignment be mentioned on this very contract? It can be. And if you're going to use the verbiage, make sure you use the verbiage equitable assignment rights. The buyer has equitable assignment rights from the seller, and you can put it in section 6 of the contract. And it pretty much gives you the right to sell the contract to anyone else. The seller has already agreed if they sign it. Okay. Right. So what did I say here? Yes, I would recommend this comment. Seller agrees to buyer's equitable assignment. So I already had written it. I forgot that I had that there. I apologize. So section 27. Equal housing opportunity. The property is sold in compliance with federal, state, and local anti-discrimination laws. And anyone who's taken or renewed their license recently, there is a federal housing 3-hour class you have to take in order to renew. Okay. And there is a lot of protected classes. Okay. And then the funny thing is there's a lot of classes that are not protected. You know, we haven't gotten to that point yet, but section 27 here is making a blanket statement. The property is sold in compliance with federal, state, and local anti-discrimination laws. Okay. Those are laws that were put in place over time at different stages of the game. Okay. So they're making a blanket statement that this entire contract falls under those categories. So if you find yourself in a discriminatory position, and I'm talking about buyer or seller, they can be held liable. Okay. So let's move on to section 28, terms and conditions of the offer. This is an offer to purchase property of the above terms and conditions. Liquidated damages paragraph or the arbitration of disputes paragraph is incorporated in this agreement if initialed. So on pages 8, you'll notice that there is actually 3 locations, which becomes 6 now because it's buyer and seller. 6 spots on that page that need to be initialed. Does it mean that they have to be initialed? No, they don't have to be initialed. But if they are not initialed, that's what it's talking about here. Most of the time, we want our clients to agree to mediation and arbitration on page 8. So you want to make sure that it's signed. If it's not, or I'm sorry, initialed. If it's not initialed, then you have to start asking questions, right? And the other side has to agree because they may not agree and they may reject the offer. Okay. If at least one, but all parties initial, a counteroffer is required until agreement is reached. And that's the part that I'm talking about. You have to pretty much talk to both sides and they both have to agree, right? Buyer may be responsible for payment of broker's compensation, right? If for whatever reason, they agree on non-arbitration and they don't agree to arbitration, sometimes in certain situations, the broker has already done their job. So do they have the right to their compensation? And the answer is yes, and it talks about it here, okay? The broker has already done their job, and if the seller decides, no, I'm not doing it, does the broker have the right, or brokers on both sides, do they have the right to their compensation? And the answer is yes, they do. Does this mean the parties do not have to agree to liquidated damages or arbitration? No, they still do. They still do. When would a buyer be responsible for paying broker's compensation? And actually, I just mentioned that. Any questions or comments on that? Pretty sleepy stuff, huh? Okay, so let's move on. We're on slide 11. We're at 642. Let's do a quick funny, right? So mortgage origination crimes, right? So one guy's telling the other guy, I miscalculated the GFE by 3 cents. How about you, right? So they hung him for that, right? They punished him, right? He said, I looked directly at an appraiser. And it's funny that they say that, because I hear this often that, oh, well, we're not allowed to talk to appraisers. And I'll say this again, guys, they're human just like everyone else. You are allowed to talk to appraisers. That's nonsense, okay? What you're not allowed to do is influence value. That's what you're not allowed to do. So that's pretty much what the rule says. So when somebody tells you you're not allowed to talk to the appraiser, that is nonsense. You can talk to them about the Braves, winning the World Series, right? That's not influencing value. You could talk to them about, the purchase contract, because they need a copy of it. So funny, but not funny, right? Needs TLC, right? And the guy's asking him, what does TLC mean? Tender loving care. And he says, no, tons of loose cash, right? Oh, I know, okay, kind of stupid. I apologize, guys, but it's pretty funny to me. I get a kick out of some of that stuff. So anyway, questions or comments thus far? We're on slide 12, so we're moving right along here. Time is of the essence, right? So this is section 29. All understandings between the parties are incorporated in this agreement. Its terms are intended by the parties as final, complete, exclusive expression of their agreement with respect to its subject matter, and may not be contradicted by evidence of any prior agreement or contemporaneous oral agreement. So pretty much what it's saying here is that this agreement is a nice little 10-page package with 32 sections like we talked about earlier, right? And any little agreement that you guys talked about before, and or any other little written agreement that might have come up for whatever reason, or not even agreement, but just publication, say, okay, it doesn't, as long as it doesn't contradict this, right? This holds precedence. And let me give you an example. One time I got a property under contract in Victorville. It was a single family residence, and on the MLS, it said that the seller is going to fix the front window, and it was one of those bay windows, and it was broken. Okay, rather expensive. I want to say it was a couple $1,000s to fix this bay window. I failed as a rookie agent. I failed to write that in the contract. So when I asked the agent, "Hey, when are you guys going to fix the window?" he said, "We're not." And I said, "Well, what do you mean? You guys said it in the MLS that you guys were going to fix it." He goes, "Yeah, but you didn't put it in the offer." So he got me. So understand, guys, that this is a provision that you see in most contracts. It's called an entire contract, okay? And what it does is excludes any oral or any other publications or anything like that that has happened outside of this contract. So if you intend for that to be part of your contract, put it in. You have sections, section 6, it gives you paragraphs. Also, you can add TOAs, which is text overflow addendum, or addenda to this contract as well as counteroffers and also buyer counteroffers. So you have the seller counteroffer, you have the buyer's counteroffer. So you have opportunities to include anything that you intend to have included in your transaction. Okay. So understand that this paragraph, in terms of paragraph 29, is pretty much telling you that you have to do that. Don't take it for granted that they're going to fix something because they said it on MLS. Put it on there, make it clear. Remember, it's not what you know, it's what you can prove. Does that make sense, guys? So this agreement shall be interpreted and disputes shall be resolved in accordance with the laws of the state of California. So understand that even though we made that statement, that this is the entire contract is what we're talking about here. That's the precedence that we're falling under. Okay, doesn't mean that the state of California laws go out the window. No, the state of California laws will take precedence, right? So neither this agreement nor any provision in it may be extended, amended, modified, altered, or changed, except in writing, signed by buyer and seller. That's the most important part. If you guys are going to make an agreement about something, it has to be in writing. It has to be in writing, and it has to be executed. What does executed mean? It means it's signed by both parties and it's dated. And it has to be clear. You know, sometimes when the buyer is saying, hey, you know what, we just did our inspection and, you know, there's like $2,000 in plumbing stuff that needs to be done. And there's another $4,000 in termite stuff. And you're talking to the listing agent, and the listing agent goes, okay, yeah, let me talk to my client. So he goes and talks to the seller, and the seller says, yeah, you know what, we'll take care of it. You know, we'll take care of that stuff. The only way that escrow knows how to amend what they're doing is because they need it in writing. So understand that escrow doesn't know what you guys are saying or what you guys are talking about or what you guys are agreeing to unless you have it in writing. And that's what it's talking about here. And guess what? It's in bold type. It may be extended, amended, modified, altered, or changed, except unless it's in writing. And that's important. That's important because agents have a problem with that. They think because they say something on an email that's what goes. No, excuse me, the buyer seller have to agree to whatever it is you guys are talking about. I've had agents write me all kinds of stuff by email, and they think that that's all of a sudden becomes etched in stone. And I'm like, no, you have to have the buyer and seller sign it. Sorry. So what happens if an escrow company accidentally makes a mistake in the escrow instructions that contradicts the actual offer? Well, we all kind of know that they would have to fix it, right? I mean, that's the obvious answer to that. There are many terms and conditions set forth on the contract that require further explanation of law. What's a good example? So there are many terms and conditions set forth on the contract that require further explanation of law. What's a good example? Anybody have a good example of something that is kind of touched base, but needs more explanation? The one that comes to mind is FIRPTA. There's so much confusion that comes across on every transaction that I do. Somebody comes up with something different, and it's pretty clear on the seller's affidavit. I'm sorry, the seller's advisory, section 3B. It also talks about it on 10C of the contract. In terms of FIRPTA, it also talks about what FIRPTA is on the seller's affidavit itself. That would require further explanation, because if you look at the paragraph, it's 2 sentences on the contract, very little explanation. So just to give you guys an example, the AS, or seller's affidavit, is one of those things that would require more explanation. So let's move on to section 30, definitions. And so I won't get too deep into this, but acceptance, right, means that it was received. Now, we've gotten a conversation, some of you and myself, about confirmation of an offer, okay? Because there's always some confusion as to, well, what was the actual opening escrow date? So what was the confirmation date, right? So I want you guys to visualize something, okay? I'm sending an offer from my client to the seller, okay? The seller receives it, although they're gonna counter the offer because maybe they don't like the price, and I'll just use that as an example, okay? So now they're gonna send back to me a counter offer, okay? That counter offer is signed by the seller. So now, if my buyer agrees, right? The buyer's gonna now sign the counter offer that we received from the seller, okay? And they're gonna date it. So guess what? That counter offer is now executed. It's executed, yes, because it's signed and dated by both parties. But how does the seller know that the buyer signed it? We have to send it back to them and they have to confirm that they received it. So that's what this paragraph talks about. Acceptance means the time the offer of final counteroffer is accepted in writing by the party and is delivered and personally received by the other party. So this is why you'll see on the counteroffer, there's a place for the seller to sign, a place for the buyer to sign, right? And if the buyer did a buyer counteroffer, there's a little checkbox. Now they don't have to confirm because you're sending that to them with the counteroffer. But let's say that there was no buyer counteroffer. Now you need a confirmation that they received it. So there's a little section on the bottom that has them initial it and date it and sign it, right? By rights, the date that the buyer signed it is actually the date that the clock starts ticking, okay? Usually it's the same day as the confirmation, not all the time. But if you're gonna get in an argument with somebody, it's the date that the buyer signed because now it's executed, okay? So we have a definition here that talks about it, and that's acceptance. So now agreement. And, oh, sorry, we're backwards here, sorry. Means this document and any counteroffers and any incorporated addenda collectively forming the binding agreement between the parties. Addenda are incorporated only when signed by all parties. So we've talked about that. Can't really have an executed contract if one party hasn't signed completely and or dated. So this is where it talks about that you have an agreement once it's executed, right? The CAR forms mean the most current version of the specific form referenced or another comparable form agreed to by the parties. And okay, so this actually touches on two things, okay? Literally last week, I received an entire disclosure packet that was outdated. And when I started looking at the forms, I'm looking at these, I'm going, wait a minute, man, these forms look a little strange. There were some things missing. And so I started comparing them to the CAR forms, and some of them were outdated almost 10 years. And I know how that happens. And let me tell you guys to watch out for this too, okay? In the Zip Forms website, you can create a template. So when you create your template, okay, you're using the current forms, but over time, those forms will become dated. So if you're using that template and you're not updating the template, you're going to be using old forms. Well, that's what happened with this agent. Okay, the majority, I want to say 70% of what I received was outdated. So guess what? This paragraph right here tells me, because it's an agreement between the buyer and seller, it tells me that we have to use the most current forms. So I had to send them back, and I said, hey guys, we can't accept these forms because they're outdated. So now here's the other part. The other part is that sometimes you'll get addenda, disclosures, advisories that were written up by the office, but they're not CAR forms. And because we're not attorneys, we really shouldn't be questioning something that's not there. So a lot of times you'll have agents, and if you happen to work at one of the offices that uses some of these forms, I know RE/MAX has some of their own. First Team has some of their own stuff. There's some outfits out there, some brokerages that use some of their own stuff. And you'll notice that they add some things in there. Okay. But pretty much what this means here in section 30C, right, is that if it's not on a car form, you don't have to sign it. So it doesn't say that here, but I can pretty much tell you. And that's because I've gotten in that conversation with brokers before. Okay. Sometimes I'll send them, because I have my own disclosure pack. Those of you who are familiar with what I do, I have an ABA that I send out, a 4-page ABA that covers a lot of different things like mold. It covers electronic signatures. It covers, don't buy big stuff when you're buying a house. It talks about that kind of stuff. And I've had brokers tell me, oh no, we're not going to have our client sign it because it's not a car form. Okay. But on that ABA, if we happen to be doing the loan, guess what? Now it's required. Because if the same broker is doing the loan, you have to have an affiliated business arrangement signed by all parties, right? Because now you're pretty much disclosing to them that you're not steering them, and they have the right to get whoever they want to do the loan. So section C, even though it's a one-line deal, that's an important little line there, right? So now let's move on to D, close of escrow, including COE means the date the grant deed or other evidence of transfer title is recorded. So we have to define close of escrow, because some people think close of escrow is when escrow maybe closes out their package. So it's defined here. It's the date that the deed is recorded. And most of us call that confirmation, right? Which simply just be the synonym to close of escrow. But that's the definition that's applied here in the contract. So copy means copy by any means, including photocopy, NCR, facsimile, or electronic. So who can tell me why it is important to say that an offer or communication is accepted only if it is received? We talked about that. I kind of went into detail, right? A contract can only be an agreement as long as what?
In writing?
Well, no, all agreements would be in writing, but a contract can only be an agreement as long as it's executed. It has to be executed, meaning both parties sign and date. Executed. Now, Celia has a question. What if the buyer signed after business hours, such as 8 p.m.? Doesn't matter. You can sign anytime. You can sign underwater. You can sign in space. Time has nothing to do with when something is executed. Okay. And it's mainly because in the contract, you have dates. You have the first section on page 1 talks about the close of escrow date, escrow to close in 30 days. Then you have the appraisal contingency, 17 days, and you have the loan contingency, 21 days. And I'm shooting off the hip here as to what the form says, but those things can be changed, right? But if they sign at 8 o'clock at night, what matters is when the other party receives it. So if you get it signed at 8 o'clock in the evening and you scan it and then the other party receives it the following morning, right? The execution date is still the date that you signed it, but they've confirmed that they received it the following morning. So you've lost, I don't know, let's say you've lost 10 hours there, okay? Understand that 10 hours becomes gray area, okay? In terms of if you are now in a position where, oh my God, I need 3 more hours, you know what? This is where you start asking for extensions. Don't fret on that time frame or those time frames, because you can ask for extensions. Understand that the contract is flexible, right? It's flexible, and you can flex your muscle by simply understanding that you can do that. Will they necessarily agree? Not every single time, But in my experience, if you simply be diplomatic with the other side and communicate, they will be flexible as well. That's just been my experience. My experience with people that are not flexible is if you don't answer their emails and if you don't answer their phone calls and you think that, oh my God, you know what? I just not going to say anything and hopefully it'll all go away. No, that's not how it works. Not in my experience. So guys, if you guys deal with things differently and find success, great. Okay. I'm just telling you, in my experience, what would be conducive to being more flexible, and that's answer your phone, answer your emails, and be truthful. Hey, I'm having a problem with this. Can you help me out? I need more time. Can I get a couple more days? I'll send you the ETA right now. That is much better than not answering the phone, because believe me, the other side they're getting mad because you're not answering their phone. So I kind of went off topic a bit, but to Celia's question, does it matter if they signed at 8 o'clock in the evening? Okay, so let me just throw something in the mix there just real quick. Let's just say it's a counteroffer. Okay, so this is what you have to be careful with, because sometimes a counteroffer will expire. There's a section on the counteroffer that says that this counteroffer is only good until such and such a time. Now it says 3 business days, but they can change it to 1 business day. Okay. And if your 8 p.m. signing happens to fall outside of that time frame, they don't have to accept it. So understand that it really has to do with timing, and understand that just because it's after business hours doesn't change anything, right? So this is where I'll go back to that statement that it doesn't matter when they sign. It only matters if it becomes a contractual term and condition that you're filing outside of. So if they're giving you 24 hours to sign, or the counter expires, try to get it signed within that 24 hours and get it back to them within that 24 hours, right? And if that 24 hours happens to be at 8 p.m., right, then it becomes an issue. So the answer is yes and no, okay, but understand why. It really is just based on the timeframes that are being agreed to and are being stipulated. And yeah, Sully Roberts said, if everyone agrees, and that's ultimately what it's about. You know, as long as everyone agrees and you can get everyone to sign that agreement and what you guys talked about, then you're cool, right? You're okay. Matter of fact, you did your job, right? You were able to negotiate and you were able to get everyone to agree and sign. And that happens a lot of times, many times in every single transaction. But a contract can only be an agreement as long as it's executed. So that's the answer to that one, okay? Oh, and I actually put the answer there at the bottom. So moving on to section 30F, and oh, this is a good one. Days means calendar days, however, after acceptance, the last day for performance of any act required by this agreement shall not include any Saturday, Sunday, or legal holiday. Meaning that if the 30 days on your contract ends on a Saturday, that actually has to end up on a Monday now because you can't close on a Saturday. If your contingency date ends on a Sunday, it has to be the following day, Monday, business day, right? Because it can't fall on a Sunday. If you extend a contract, contingency dates, or any other kind of dates, closing dates, on the weekend or holiday, it will be extended automatically to the following business day. That 30F has saved me so many times, because let me tell you something, most agents don't know that. I've had agents send me nasty emails. You have to remove the contingencies. Today's the last day. And I said, no, we don't. Today's Saturday. And then I show them 30F and they said, oh my God, I've never seen that before. Well, there it is. So days after means a specified number of calendar days after the occurrence of the event specified, not counting the calendar date of which a specified event occurred. Now, this is important because I get this often, not too much, but often. That when you're starting to count the days, So let's say it's 30 days that we're supposed to close, okay? And let's say we opened escrow on the 25th, okay? You're not counting the 25th as a day. So if you're looking at a calendar, you start counting 1 on the 26th. And the reason why is because there's 24 hours in a day. So if you go to 26 and say 1, that is 1 day, 24 hours. You're not saying 1 on 25 and then 2 on 26. Does everybody get that? Right? So when you're counting days, that's what this is talking about. Okay. Days prior means specified number of calendar days before the occurrence of the event specified, not counting the calendar dates on which the specified event is scheduled or occurs. So it's kind of the same thing, right? Days prior. Delivered or delivery, unless otherwise specified in writing, means and shall be effective upon personal receipt by buyer and seller or the individual real estate licensee for that principle as specified in sections real estate brokers on page 10, regardless of the method. So now you can go one extra mile on delivery on something called a DLT, right? Or it's a delivery addendum. Okay, and the DLT, which I'm surprised they don't have it here as a reference, but if you want to go the extra mile to say, okay, you know what, I have a guy that just every time I send him something, he swears up and down he never got it, right? And we've all dealt with people like that. Okay, God bless them. You can have them sign what's called a DLT, meaning that if you deliver something, right, they can't say that they didn't get it. So that's an interesting little addendum. Most agents that I know won't sign them, nor will their clients, and I would advise that you never sign a DLT, right? But this is talking about here that if you deliver something to them, that it's considered delivered, right? So it is important to watch the contingency removal dates as well as closing, and I would say yes. That's a question. It is very important. So electronic copy or electronic signature means, as applicable, an electronic copy or signature. And I don't know if I highlight anything here. I did. Complying with California law. What? Buyer and seller agree that electric means will not be used by either party to modify or alter the content or integrity of this agreement without the knowledge or consent of the other party. So now we all know that there is software that you can jump into a form that's already been signed and you can start altering things on it, right? So anytime that happens, you need to get their initials on it. That's pretty much what this talks about. But the reason why I'm talking about now California law when it comes to electronic signatures, and let me see what I put here at the bottom. Oh, okay. Who can tell me what the California law is for electronic signatures? Anybody know? So law, let's move on to K, and then we'll jump into that answer real quick. Law means any law, code, statute, ordinance, regulation, rule, or order which is adopted by a controlling city, county, state, or federal legislative, judicial, or executive body or agency, right? Repairs means any repairs, including pest control, alterations, replacement, modifications, or retrofit of the property provided for under this agreement. Signed means either a handwritten or electronic signature on an original document, copy of any counterpart. So let's move on to the question again. Who can tell me what California law is for electronic signatures? Anybody know what the law is on electronic signatures? Well, it's called the validity rule, right? The signer must give you written permission of their consent to use the technology. Okay, now, we used to use a form called the ESV, the electronic signature verification. Okay, so now what is the validity rule? What the validity rule talks about in the state of California is if you're going to use the electronic signature technology, the first thing is that, and let's say that I'm the agent and I have a buyer, okay? First of all, I have to tell him that I'm going to use that technology. And second of all, I have to have something in writing stating that I told him that we're using this technology and he's giving me permission to use it. That's called the validity rule. Okay. Now, Zip Forms and DocuSign and all of the signature software that's out there has created something that is now in compliance with the validity rule. We used to use what's called the ESV, where they would have to sign wet sign that document. So we would have in our file, we would have permission that we're using electronic signatures. But now what's happening is, because we kind of stopped using the ESV, okay? What's happening now is that when you send out an e-sign email link to a client, before they sign, they're acknowledging the terms and conditions of using that technology. So they click the little box that nobody reads, right? And pretty much in that box, if you were to click, see more information, there would be all this information on the fact that, number one, we're using this technology, and number two, that you're giving the user of the technology permission to do so. That's the validity rule. So now what happens is, when we receive the document in the email, now you could click on the document, and now you have the signed version, okay? But now right underneath it asks you, would you like the signed certificate? Okay. And so usually what I do on my files is I will save one signed certificate as long as all parties have signed. So I wait until, all the agents and whomever I'm getting to sign has signed, because what it does is it verifies their email address and their signature. And I have a certificate that they actually clicked on that button saying that they gave permission to use the technology. And now I have that in my file. So that becomes my ESV, okay? So understand that that's called the validity rule in the state of California. And it's telling them now under these definitions that it is complying with the law in the state of California, which is that they've given you permission to do so. Can there be a person say, no, I'm not giving you permission? Yeah, and I've had people say, oh no, I'm only live signing things. I don't do e-sign, right? Any questions or comments on that section? All right, moving on to section 31, right? So expiration of the offer. And so this is interesting because why do we need an expiration of offer? Well, if you send out an offer to a client, to a seller, you don't want that offer floating around for months where the seller could potentially sign it and send it back to you. Because understand that when you send an offer to a seller, the buyer has already signed it. So you don't want them coming back 3 months later and saying, oh, okay, yeah, we'll accept your offer, because you may have another property under contract. Or you might have something else going on, or you might decided to move into a different city, right? So you have to have an expiration of your offer. So what's built into the contract is, I think I highlight, yeah. What's built in is on third business day, this offer expires, okay? Now you can change that if you want to. You can put a date on it. Let's say that your offer expires in 1 business day. You can put that there too. So that's the expiration of offer, okay? Now, if you have a buyer that wants to buy a property, let's say under their corporation or LLC or a trust, okay, that's what you call representative capacity. The person who is the representative signer of those entities, right, has to fill out a form, the RCSD, and in this case, because it's a buyer, B, you check the little box and you have them signed under buyer. Even though, right, the name of the buyer could be ABC LLC, or let's say ABC Incorporated, right? Because that's how the property is going to be vested, because that's how they're buying it. They're buying it under the corporation, right? So you need the representative capacity form filled out and signed by all parties if that's the case. If it's not an individual that's buying the property, then you need representative capacity. That is disclosing to the other side that this person is the managing signing partner for this company. Because, you know, a company could have 100 people in it, but only one signer. And that person is now representing themselves as a managing party. And as always, if there's additional people, you know, meaning more than two, because there's only 2 spots here, we use the ASA additional signing addendum to add those additional parties, right? So why is it important to date an offer and also have an expiration? We kind of talked about that already. When signing for a corporation, trust administration, is important to include the RCSD. It contains the appropriate verbiage indicating the signer's capacity, which I just went over. And then obviously the ASA is for more than 2 individuals signing. So I think we're going into questions. In section 22, when there is a dispute between parties, what does a buyer and seller have to do to comply with the contract provisions? So in section 22, which is on page 8, we went over that a little bit. I didn't go too much over it. Does anybody remember section 22? Section 22 is arbitration, right? And pretty much what they have to do is they have to request it. So that's the answer to the question. They have to request arbitration, right? You can't just assume that if you're in a dispute that it's just going to happen. No, there's a form that you fill out and you submit it to the other side. When a client asks you for recommendation of any provider or services, what is the best practice method? So what is the best practice method about recommending a provider? I have a way that I go about that. And anybody have any you know, when somebody asks, hey, do you know any good inspection companies? How do you guys deal with that?
We give them 3 different people and let them choose.
Yeah, see that's a good thing. Now, the first thing I was going to say was you should email that information to them, right? That we have proof that you gave them 3. But the power of 3, yes, Robert Sully, good job. That would be one of my recommendations, right? And you give them 3, but then in the same email, you put a little provision on the bottom to also, they have other options. You put a little provision saying that you can also look on the internet for whomever you'd like. And it's pretty much taking a step back because, you know, you can know 3 inspection companies, right? Or 3 inspection guys that you're fairly familiar with, right? But you're not going to know everybody on the internet. So you're kind of taking a step back away from that. But yeah, when you use 3, it's kind of now making that separation from you and those individuals. Concerning section 29, what happens if the contract is out of date? Anybody dealt with an out-of-date contract? So this is one of the things that you know, we talk about. Well, the seller has really no right to cancel a contract. Well, if it becomes out of date, now they just been given the right to cancel. Obviously, they have to go through the process of notice to perform and that good stuff. It also I would imply that now diplomacy is involved because now you have to kind of renegotiate. Sometimes sellers want per diem charges, other times they don't, but it's really just a matter of talking with them, right? But it definitely causes problems, contractually speaking, right? Unless you address it. So important to address the dates, contingency dates and contract dates. Most agents ignore that stuff because they think, if they don't say anything, it's okay. We can just keep moving forward. They don't realize that they're giving you a little bit of power on the other side. Okay. And sometimes agents don't take that power and use it, and others do. So this is where, you know, you have to be mindful of what's going on with your dates. So do yourself a favor. Anytime you get into a transaction, write those dates down. Me as a transaction coordinator, I always send that information out so you can make a note of it. Take a picture of it, right? Pay attention to those dates. Ask for extensions if you need them. Very important. Can a buyer or seller agree to a contract that is expired? Can they agree to a contract that is expired? Anybody? Everybody's afraid to answer wrong. Hey guys, you know what? I got to tell you, there's really no wrong answers. Okay, what I'm trying to put on the table here is solutions, obviously. But Karen did say no. Can a buyer and seller agree to a contract that is expired? And the answer is yes, and then that's because I've done it. I actually made an offer for a client on an expired listing. Okay, the seller sat on it for 3 weeks. And so now the offer's expired because we just all saw that the offer expires in 3 days. And buyer and seller agreed to move forward with it. So as long as they agree, you simply write an addendum reinstating the fact that they both accepted it and then we're moving forward. So the answer is, yeah, you can, again, as long as a buyer and seller agree. And you do your proper documentation. Remember, it's got to be in writing. You have to put it in writing. You know, I would make a note on an addendum saying this offer expired 3 weeks ago, but buyer or seller decided to move forward. We're reinstating as of this date. Expiration dates to be this, this, and this. And so you would simply just clarify what you're doing. Now, some agents, and I've had this happen before, some agents will say, no, you know, do me a favor, rewrite the offer for using today's date. So now you have a brand new offer on the table, right? And I've had that happen too. But these are different ways. These are different ways that you can do it, okay? But now to Karen's point, let's say the reverse happens. Let's say that Karen makes an offer on a property and it sits there for 3 weeks, but now the seller has kind of changed their mind. I'm sorry, not the seller, the buyer, which Karen is representing. Does the buyer have to accept the fact that the seller signed it? And to Karen's point, no, they don't, because the offer expired. They would literally have to agree to reinstate that offer. So kind of a trick question, right? Kind of a trick question. So it's one of those yes and no kind of questions, but understand what can be done, okay? So we're on slide 15. Oh, I'm sorry, slide 16 and 724. So let's keep moving, which we're coming up to the end here now, acceptance. Okay, so section 32, seller warrants the seller is the owner of the property and has the authority to execute this agreement. Very important on that. I should have highlighted that. Seller accepts the above offer and agrees to sell the property. The above terms and conditions. Seller has read and acknowledges receipt of a copy of the agreement and authorizes the broker to deliver a signed copy to the buyer. Okay, unless of course, right? Unless of course there's a counter offer, which if you check the little box, right, and then you date the counter offer that you're sending. Now, I see so many offers come over where there is a counter offer and this box isn't checked and there's no date. And pretty much because other people are looking at this contract, it's very important that you fill section 32 out if there's a counter offer, because any reader that's going to read this, and if it's not checked and dated, is going to assume that there's no counter offer because it's just being accepted. The offer is just being accepted. So understand, listing agents, understand that if you are delivering a counter offer, make sure you check the box and make sure that you date it. And then the same thing now for the seller, the representative capacity, right? You want to check, and there's that little box there. Representative capacity is the next line, right? Now this is the representative capacity for the seller. If the seller is the owner of a corporation, if the seller is an owner of an LLC or is the administrator of a trust or successor trustee, right? We need to check that box, right, for representative capacity, and then the seller signs. Okay, and then of course, if there's additional sellers more than two, then you use the ASA. Now, if you're simply just accepting the offer and not giving a counter offer, the seller can also initial, right, on the initial box there, noted there on the left, but it's not required. If the seller signs on section 32, that's enough, it's executed. So if section 32 box for counteroffer is not checked and dated, what does it appear if signed by the seller? It appears that they just simply accepted the offer. So I just mentioned that. Who initials under confirmation of acceptance section, right? It's the buyer. So if the seller is accepting their offer without a counter, right? They're sending the offer back to them. How do we know that they received it? Well, they're confirming. But again, the buyer doesn't have to sign that, right? And it actually says it there somewhere. A binding agreement is created when a copy of the signed acceptance is personally received by the buyer, authorized agent, or not confirmed in this document. So it's pretty much saying that doesn't need to be confirmed. Completion of this confirmation is not legally required in order to create a binding agreement. What creates a binding agreement is the seller signing on section 32, not the receipt from the buyer. Is it nice to have a receipt from the buyer and a confirmation? Yes, it's nice to have. But if nobody's in dispute, then it's not required by law. So there is a difference. Buyer's agent can sign the confirmation. Yes. Yeah, it's them or authorized agent, and it says it there right before the line for the date. Okay. So there it is right there. See, buyer's authorized agent. Any questions or comments on that slide? So here we are on section 32 now under for the brokers. And this is my favorite line, section A, real estate brokers are not parties to the agreement between buyer and seller. So can the agent say anything about anything, really, without having the buyer and seller actually sign something to agree? Nope. Oh, I'm sorry. You know what? And I'm noticing now, I said DLT previously to confirm that they've received a communication. It's not DLT, it's DNA. That's the name of the form, because the DLT I just noticed right here is for commissions. Most or some listing brokers want a DLT from the selling agent office for tax reporting purposes. And if the brokerage is a corporation, they don't have to worry about it, and they'll just say that on there. Now, in terms of the broker's compensation, okay, and let me just move over to the section here. The broker's compensation, okay, is as specified on MLS. Okay, before we used to verify the broker's compensation with a CBC, which is the CAR form that we use, which is cooperating broker compensation, or CBC. Okay, we used to use that often, but now we rarely use a CBC. The only time we use a CBC is if, number one, the property isn't listed on MLS. So now there isn't a advertised specified amount for the commissions, okay? Or you're going to modify the commissions. So understand, guys, that when you modify commissions, those commissions are not supposed to go back to the listing agent. When you modify commissions as a selling agent, those commissions are supposed to go back to the seller. If the commissions are purposely supposed to go back to the agent, you need the seller's permission. Because remember, the seller is the one giving permission on what the specified commissions are supposed to be, not the broker. So understand that when you're using the CBC and you're lowering your commissions, the commissions that are being revealed now. So let's say it's 2% and you're lowering it to 1.75. Okay, that 0.25% is supposed to go back to the seller, and that's an MLS rule. And if you're caught doing it the other way, you can be fined, violated, and or suspended. Okay, understand that that's a breach of contract. So when using the CBC, tread lightly. So this part, section D, talks about the broker's compensation. Simply said, it's what is being published on MLS. What I always recommend is when you make an offer, get a printout of the active listing. I've had agents literally change the MLS compensation the night that they got the offer. I said, oh no, it was 1.5%. I said, no, it wasn't, it was 2%. Here's the listing. Right? Do yourself that favor, okay? Make yourself a PDF of the listing and have it when you send the offer in. That way they can't change it on you, because I've had agents do that before and they've tried, okay? But remember, it's not what you know, it's what you can prove. Okay, so there's a little nugget for you guys today, okay? Presentation of the offer. Oh, okay, well, here I highlighted it for the CBC. And then now the DLT has to do with declaration of license for tax purposes. Again, some brokerages on the listing side will ask you for that, and you have to give it to them, okay? Now, presentation of the offer. Pursuant to standard practice 1.7, if buyer's broker makes a written request, seller's broker shall confirm in writing that this offer has been presented to the seller. And that's actually lower down on this page. Okay, so it used to be common practice to use the CBC in all transactions to confirm the selling office commissions. But as mentioned in section D, the last published BAC, or buyer's agent commission on the MLS, is used now to confirm the commissions. What is important to do before, and I said print out a copy of the active listing before you submit the offer, so you have it in your hands. So section 32 now, finishing up here, the escrow holder acknowledgement. So typically the escrow won't receive this document executed until after a few days, and so they need to fill this part out. The important part on this particular section is the escrow number, right? Because the address and the escrow holder's name and that kind of stuff, we get most of that on the escrow instructions, their license number, but then the last line where it says Department of Business Oversight, Department of Insurance, or Department of Real Estate. Now, anybody who's familiar with these contracts, Department of Business Oversight isn't even there anymore. It's something else now, okay? And that was a revision that was done, even though this says revised December 2018. If you look at the new one, it's different, okay? But for example purposes, it's important that they check one of these boxes, because if it's Department of Real Estate, you can't get a QS from them, okay? Because that means it's a broker escrow, and broker escrows don't do qualified substitute, right? This is the section also where you show here the presentation of the offer, broker's initials, and the date. So it shows when they presented it, right? And or when it was rejected. So you need the seller's initials, meaning that you presented it to the seller and the seller rejected it. Here's the date, and then you send it back to them, right? That's the clear cooperation policy now that we're showing the agents, because see what happens a lot of times is agents would be very upset. Well, you know what, I submitted an offer, but they never answered back, right? Well, under the clear cooperation policy, agents have to answer you back or they can be fined. So this is where you would answer, if you're the listing agent, this is how you would answer them back. You presented the offer and or you rejected the offer. That's how you answer them back. So we are on slide 18. Let's see what else we got here. Any questions or comments on that? So yeah, so here you see, you know, they have the deposit, uh, seller statement information, that they're the escrow holder, right? They have, and this is where I mentioned about these three check boxes here, very important for them to fill out. And then this is how you take care of your clear cooperation policy on page 10, and then obviously the buyer initials at the bottom. So Karen, DBO is now DFPI, yes, Department of Financial Protection and Innovation. Thank you. And as I mentioned before, because I actually printed this out when it first came out, it's changed since then, and it's mainly because Department of Business Oversight, I think, went away. So now either that or they've changed to Department of Financial Protection and Innovation, right? But it's important to know which kind of escrow they are. That way you know how to act on your end, okay? And then the obvious thing, I put the little arrow there to make sure the buyer initials at the bottom if the offer is accepted. But in terms of the clear cooperation policy, this is where you would address that. And this is how you can communicate what the seller's sentiment is now professionally. Any questions or comments on that? So let's do final thoughts, okay? So, well, that wasn't such a chore, right? 10 pages of relentless contract finally finished, although a daunting task to go through 6 exhausting classes of, quite frankly, boring contract. It is all necessary. 32 sections is all necessary. And believe it or not, now that we're going to see the new one with 16 pages, there's probably going to be more sections that they added and more stuff, right? And after we look at that, and I'm guessing that I probably should have that presentation done maybe in February. After we look at that, it's probably going to all be necessary as well. So that means that there's stuff missing on this one that we probably feel at some point were necessary now on the new one. I remember back in the day, a purchase contract was just 2 pages. And so was the appraisal, by the way. Over the years, it grew and grew and is currently 10 pages at present. In my opinion, it is because of lawsuits, buyers and sellers, dishonest behavior that have required the need for such vigilance in a contract. It is important to understand what is being said, how it's being said, and even gives further instructions to understand and acknowledge even more. It gives deadlines and ways out of the contract, attempting at all times to be fair and just in a way it is executed. All the time being facilitated by agents who aren't even part of the contract. I would recommend and advise that you read the contract disclosures and reports on every single transaction. You will find it becomes easier and easier the more you do it. But by recommendation comes with a price. Appropriate, integral, loyal, honest, and fair dealings with your client. Okay, Larry. Larry just dated himself, right? And he said that the purchase contract used to be a half sheet. Now, you know what? I wholesale property, okay? And right now we're wholesaling property in Arkansas, Little Rock, in Arkansas. And our purchase agreement is a page and a half. So can a purchase agreement be very tiny? Yeah, it can be. But because we're dealing now with lenders, escrow companies, title companies, inspectors, there's so many other agents, brokers, wholesalers, trust companies, corporations, LLCs, all of these different angles that a transaction can go. It requires that additional documentation. Can those things be added to, my 1.5 page deal? Yeah, it can, right? And it does. There are many addendums that we got to write. But in order for us to truly find ourselves in a position of really non-liability, because that's really what we're trying to avoid, the attorneys at CAR and the attorneys at the National Association of Realtors have come up with this 10-page, and now coming up in December, a 16-page protection mechanism for all parties. It protects buyer and seller. It protects the brokers. It protects the title companies. It protects the escrow companies. It protects everybody. And it's pretty much forcing us to play nice. That's the purpose of the purchase agreement. So in terms of final thoughts, if you take nothing else out of any of these classes, that's it. It is a protection mechanism. So any other questions or comments? All right, so let's move on to affiliates and resources. There's me and my information. You guys know what to do with that. If you want to, there's Mr. Larry. I think he's still here. Yep. There's his phone number and email address. If you guys need some information and or want to learn more about title, Larry is your man. Larry is kind enough to share with us all the handouts that I send out on emails, usually Monday or Tuesday. Recently, Larry was able to give us a copy of the new RPA, which is a sample. And so anybody who didn't get it, send me an email. I'll shoot it over to you. It's fast and easy. I haven't had the opportunity to read the whole thing, but obviously, because I'm going to tear it apart, I'm going to make that new presentation, and hopefully I have it ready for February or March of next year. Or sooner. I'll try my best to get it out there because I'm working on other ones right now. And it's been so busy lately that I just haven't had time, right? There's Miss Elizabeth Montes information. She's with ERS Mortgage. Phone number, email address. If you need a loan approval or anything like that, she can help with that stuff. I mentioned Mr. David Plummer. He is a real estate coach and mentor. He has his free classes on Saturday at 8:15, roughly till about 9:45. A good motivational push if you guys feel that you are being complacent and or just need somebody to look over your shoulder and get you to act. Dave's your man. You know, I do a little bit of that. I mean, if you call me, I'm always encouraging and motivating as much as I try to be, but I don't feel that I'm as good as Dave. Dave, I really do endorse his product. So there's his meeting ID and password, again, Saturday in the morning on Zoom. You guys are welcome to go on. It's free. Okay. So anybody on that. And then property ID, Shamim is our representative there for property ID. You guys are welcome to give her a call if you have any questions about NHD products. Okay. That said, guys, that was the final part of the 6-part presentation. Thank you guys for toughing it out with me. This is being recorded. And like I said, in the next couple of weeks here, I'm going to include the link to the channel of all the recordings. Okay. Sully and Robert, you're welcome. Victoria, you're welcome. Karen, you're welcome. As a matter of fact, your files should be coming over tomorrow. I squared up with Eddie today, just so you know. So again, I'm going to try to get the new RPA class up by February so we can take a look at that and tear that one apart. Hopefully you guys got some good questions on that. And so next week, I'll be doing a recap of the broker file because I didn't record it. I have parts 2, 3, and 4 recorded, but I don't have part 1. So I'm going to redo that class. You guys, if you could just do me the favor and just sit in on it, just so I have somebody to talk to, because those of you who have already sat through it probably don't want to see it again. But like I said, I'm trying to build the library, so you guys will be helping me to do a better job on it. Okay, so I invite you guys next week, even though it is a review or a repeat of what we did some months back. Okay. So yeah, Mr. and Mrs. Doshi, anytime. You guys are welcome to come on anytime. And then thank you, Larry. It was the last 2 pages of the RPA, which, you know, it really creates the content for these kind of presentations because a lot of it, you know, we take for granted, a lot of it we assume, and a lot of it we learn through Paradigm, which shouldn't be. You guys should be reading this stuff, especially if you're having one of your clients sign it, right? So it's really just reading it. Understand that, you know, I didn't take college courses on any of this stuff. All I did was read it, and then I've lived it because I've gotten in the conversations and had to research what was supposed to happen. What does the law say? You know, I researched that stuff. So that's how I'm sharing it with you guys. But at some point, it becomes a matter of opinion. It becomes a matter of how you interpret the information, right? Some of us could interpret it differently. And sometimes, you know what, I could see your point. You know, I might have an opinion about one of the sections, and then I'm looking at it and I'm like, you know, somebody brings a point to me and I'm like, you know what? I could see your point. So now it becomes a gray area. And so it requires more research. And guys, if you are truly professional, you will research those things. Don't just take them for granted. That makes you that better agent. And at the end of the day, what do I always say? I'm trying to make you guys better agents so you can make more money. It's about profit. So the technical piece that we're talking about here in terms of understanding the forms and the contracts, it's one piece of the puzzle, okay? There are many others, and we've talked about it in terms of you being competition for others. Good advertising, consistency, right? These are all things that are very important in our business in order to profit. Not just this. I'm not just telling you this. This is why I'm telling you about Dave's classes, because it's motivational stuff. It's about getting out there and getting your name out there and having people know what you do. Because if you know this stuff, right, and you're able to get business, you've made that connection and now you're profiting. This is your business of choice. So it's going to get you out there and it's going to get you the business that you need, mainly because if you're interpreting the contracts the way they were meant to be used, you look like Superman, okay, if you win that battle with the other side. You know, it goes back to that chessboard analogy that I always use, that if you know how to play chess and you know how the pieces move on the board, but the other side doesn't, you're going to win every time. And that's going to make you look like Superman. Guess what? You just got all the referrals. Because now you're, well, and some of you Superwoman, right? It creates that super nature, if you will, right? Because now you look like that person. You look like, oh wow, you know what? My agent, they know their stuff, right? So this is why I bring this component to the table. I wish I could be more motivational. That's just not my thing. I mean, I do some of it, and some of you have sat into some of my tactical training, but it is a little bit more technical as well when we talk about farming, when we talk about competition, we talk about the sell, right? The motivational stuff, unfortunately, I don't have the power behind it. And this is why I endorse Dave's product, Dave Plummer, because if you listen to what Dave says and what he talks about and the way he comes across, man, I come out of there and I got goosebumps, you know, coming out of the Zoom meetings, because it's very motivational. It's motivational stuff. It gets you to move. It gets you to be consistent. It gets you to remember what it was you were doing the day before. You know, that's important stuff. So anyway, that said, unless anyone else has anything else, it is 7:50. I don't want to go much longer because, you know, it is coming up late. So anything else, guys? I'm getting ready to sign off. Thank you guys for coming again. I really do appreciate you guys coming on and hanging out with me on these Zoom meetings. This one, I'm actually fairly grueling, you know, 6 presentations in a row is some heavy stuff. And for those of you who missed some of the other ones, like I said, I'll have the link up in a couple of weeks. Just check out the emails and I'll put like big bold type, you know, this is the link to the channel that I'm creating. Okay, so that said, guys, we are in November. So coming up on Thanksgiving weekend and Thanksgiving week. That week, like I mentioned before, I will not be doing class. I'm going to take a break. You know, it's a little stressful on the vocal cords. But anyway, you guys get out there and make some money. Okay. Give me a call if you have any questions or need help with anything. Give Larry a call. He's always there to help as well. And I also mentioned Liz and Shamin with property ID. So with everybody on that previous slide can help you be successful in real estate, including myself. Okay, so there are resources out there that can help you. All you have to do is ask. That's all you got to do, and it's there. And so this is why, you know, I don't charge for this stuff. This comes out of the kindness of my heart, and I wish you guys good health and profit. Okay, so that said, I'll see you guys next week, hopefully. Okay, have a good night. I'm signing
Yeah,
out.
thanks.
All right, thanks, Mr. Larry.